So we figured out who our employees are. We figured out who is and is not an independent contractor. We figured out who's entitled to overtime and who's not. We're paying them correctly. We've got all our records in a row. Inevitably, you will eventually hire somebody that's just not working out. As most of you probably know, something happens when you become a small business owner. The way that you look at work and your performance standards suddenly change. And you all know that it's very difficult to find an employee who will have quite the same standards that you, the owner, has. So inevitably, some sort of an issue will come up. So what do we do with some of these performance issues? This is one where the law doesn't really give you any, here's the bright line rule, this is what you absolutely have to do. But I think there are some best practices that can help you avoid problems later on down the road. The first is making sure that you're spotting the issues and that you're documenting them. So you should have some sort of a performance evaluation process in place. You need to be consistent about using it, implementing it, and following it. Related to that, you should have a progressive discipline policy. And we've probably all seen them, right? Your first offense, if it's something minor, we'll sit down and we'll talk about it, right? And we'll make a note in your file that we talked about it. And then if things continue to go downhill, then we'll do a more formal write-up of what happened and what went wrong and what we're going to do about it, all right? And if that continues, then we're gonna put in a corrective action plan. You've got to meet these things over the next however months or weeks or whatever the case may be, and get it together, or we're going to let you go. And then up to termination. And of course, it's all going to depend on what the problem was, what the conduct was, but something along those lines, and making sure that you're following it. Nobody likes performance reviews. None of us like them when we worked for anyone else. Your employees still don't like them. You probably don't like giving them. But keep in mind that this doesn't all have to be negative. It's also a chance for you to give good employees feedback, to kind of recognize them for the things that they're doing and doing well, for their awesome behaviors, and to identify and coach people that aren't quite meeting your standards. And if this is really just completely bugging you, like, I really don't want to do this, I hate having to criticize anyone, consider using self-evaluations. At least in my experience, people are pretty aware of what they're doing and what they're doing wrong, and where they're living up to expectations and where they're not. And something about having to write down on a piece of paper, yeah, I really could have done that better, will make it pretty obvious and take some of that sting out of you feeling like you've got to berate the employees. These are incredibly important to have, especially if you have to fire the employee later on. Workers' comp is very employee friendly in my experience. However, the first thing they will ask for is, what was your discipline policy? What's in your employee handbook? Was there a reason that this person got fired? Now, don't be too alarmed. Unemployment works a lot like insurance. Sure, you get a little bit dinged if you get into a car accident, but your rates typically don't change dramatically unless you have a lot of claims over a short period of time. I think that unemployment works very similarly, but they will ask for that. Now, in my experience, unless the person is just like completely off the rails, they're more likely going to say, no, this person tried their best, so we're going to give them unemployment. That's going to affect your insurance rates. But oftentimes not nearly as drastically as you might be expecting, unless you're out here just firing employees every few weeks or something. Making sure you're doing those performance reviews, I think at least annually, but I think it's a good habit to get in the practice of doing them more often with your newer employees who are still trying to get acclimated, still trying to get their feet under them, still trying to figure out what's going on, or with any of your workers who might need some improvement. If it doesn't make sense to give John a performance review today and tell him about all the problems that he's having and then not check in with him for another 12 months. That's just going to create, at the very minimum, tension, at the very worst, problems that aren't being corrected. Now, the one issue that I think people get into where they can cause some legal issues with their performance reviews is just simply not being specific. This sort of vague, hey, you just need to work harder, or you just need to do a better job. Not only does that not give anyone any information in order for them to improve, but then if later on they don't do whatever the miraculous improvement is that you're looking for, those are the people that start to wonder, I wonder if there was some other reason why I got fired, right? Is it because of, is it age? Is it because they're a woman? Is it because they're a minority? Because you weren't giving them specific feedback, those suspicions will creep in and can cause issues. So be specific. Here's a specific example of what you did, and this is how I'd rather that you do it. Set deadlines, be realistic about your expectations, be honest with people. And then the other one is making sure that you're evaluating a person for their performance and not for their personality, especially where that personality trait could, for better or worse, be misconstrued and perceived as sexist or discriminatory. So for example, when you have a woman employee and you tell her that she's simply being too emotional, what does that mean? How is that supposed to help her improve? And when you start to see a track record of all of your female employees either leaving, quitting, or getting fired, eventually one of them is going to take that and say, I think there's discrimination happening here, whether that's the case or not. Or another example, telling your African-American employees, you're just too angry. You seem angry all the time. Again, for better or worse, that is always going to come across and sound discriminatory. So make sure that you stay focused on actual performance, right? Here's what you did. Here's how you could have done better, as opposed to personality, things, those personality traits, those quirks, those types of things that could easily be misconstrued and aren't going to help the employee improve anyway. Internet is a big one, particularly in the modern era. We're almost all on our computers all day. If we're not, we're probably on our cell phones most of the day. And so we get a lot of questions about how much we can monitor what our employees are doing on the internet. How do we deal with some of the off-duty conduct, especially that we see on the internet, that perhaps makes the employer look bad. As an employer, you can certainly set reasonable restrictions, maintaining network security, right? You can have your restrictions about not downloading files and things like that to your work computers just for the sake of security. You can certainly prohibit illegal activities and non-work related activities at work, right? I mean, those are pretty obvious and fair game. Where we run into some problems and some tension is with personal use, or we try to prohibit all personal use of the internet while at work. That creates a problem because I can guarantee you're not enforcing that policy across the board. And when you start to treat different employees differently, you're going to create, again, at minimum tension, at worst, an attitude of, well, I think there's some discrimination happening. So you want to be careful that you're not creating this sort of draconian policy that you can't enforce and that'll be misconstrued anyway. But you do want to have some sort of a written policy. Let your employees know, here's what our policy is, here's how we enforce it, here's what our expectations are. I don't know that there's an employee in the world right now that you can keep off of Facebook for their entire shift, or that you can keep from checking their personal email or checking in on the news or whatever the case might be. So be realistic. What does your policy actually need to be? Why are you setting the rules that you're setting? And if it's because you think you can magically make somebody work a full 8 hours out of their 8-hour day, it didn't happen when you were the employee, it's probably not going to happen now. Related to this is this idea of workplace searches, which will sometimes involve devices like the computer, if you're giving your employees cell phones, those types of things. And sometimes it's just, the desk or a locker or something like that. Again, best practice is to have a written policy. You can certainly do that, but you want to be careful with how you're doing it. And the flip side, I will occasionally talk to a small business owner that for whatever reason is just naive and thinks that, well, my employees are all angels, right? My employees are perfect. They're wonderful. We're a small business family. They would never do any of these things. Here's what the statistics tell us. 60% of workers have admitted to sending or receiving adult emails at work. 55% have admitted to sending or receiving personal emails that were racist, sexist, or otherwise offensive. 10% have admitted to receiving confidential information about another company. Talk about getting you into hot water. You're getting sued by one of your competitors because your employee brought something to work that they shouldn't have even known about, or that they brought over from a former employer. So you need a policy to address these types of things, again, whether it's electronic or whether it's an old-fashioned paper file in a desk. And that policy also needs to address when stuff gets deleted, when does stuff get trashed, and how long do we keep stuff? Particularly if you are involved in litigation or you even get threatened with litigation, that's the time you want to make sure that nobody's deleting anything, because hiding evidence or trying to get rid of evidence will make any case much worse than whatever that evidence might have been. So again, your workplace searches are generally permissible, except in those places where employees have a justifiable expectation of privacy, right? So, and this should be obvious, but again, we'll get questions about it. You know, you should not be searching the restrooms. If you have locker rooms where employees change, you know, there's a reasonable expectation of privacy in those places. Be careful about that. You know, conversely, there is no hard and fast rule about, say, the employee's purse or backpack that they brought in. So you want to kind of keep in mind, you know, what's reasonable in this situation? You know, what would a reasonable third party, a reasonable other employee think about what's going on here? Why am I trying to search every nook and cranny before you institute these types of policies? And of course, whatever you decide that the policy is going to be, make sure to get that into your employee handbook and make sure that people are aware, hey, you bring these personal belongings into our building, we're going to search it if we have a reason to. But again, just don't be more invasive than is actually necessary. Now, before we talk about drugs and alcohol, I want to touch on off-duty conduct. Ohio does not have a general right to privacy for employees. So when it comes to their off-duty conduct, you will sometimes see this in other states. And so sometimes people will have the misconception of, well, I can't fire anybody for something that they did off the job. At least here in Ohio, that's not technically true. However, Ohio does recognize a right to privacy that falls under this wrongful intrusion into one's private activities, which is a bit of a mouthful, but it's an invasion of privacy that rises to the level of outrage or causes mental suffering, shame, humiliation to a person of ordinary sensibilities. So again, this is one of those where it's not a hard and fast rule. There's not a, this is exactly how it works. But if you're doing something that would be outrageous or humiliating, that's where you're going to bump into problems. As a practical example, I think we see things like this when, you know, something happens, somebody does something embarrassing to the company, it goes viral, and then there are all the shouts on Facebook and social media, you've got to fire that person. And in the course of doing so, you think that you're somehow helping yourself out by making a big public statement. And the public statement adds more details and just kind of fans the fire. And now you have added to what's known in the general public and you've humiliated that person. And so that person then sues you behind this right to privacy. It would have to be a pretty extreme example, I think, for that to happen. But again, you know, keep in mind, particularly as a small business or a small nonprofit, you know, that litigation or that threat of litigation, even if it's frivolous, can eat up the next, you know, year and a half, 2 years of your time and trigger a lot of legal bills, even if you were right. So a lot of times we want to avoid that if at all possible. So generally, yes, you can fire somebody for something that they were doing off duty that had nothing to do with the business whatsoever. However, if that conduct was somehow protected, you need to think twice. So what do we mean by that? Whistleblowers is probably the most obvious example. You know, you've got somebody complaining on Facebook about how their employer won't pay anybody overtime, right? Don't try to fire that person for that. That's off-duty conduct that is protected. They've got the right to make those complaints. Even if it is making your business look bad, you're not going to win that battle. That's also going to fall under what the National Labor Relations Board considers concerted activity. So if employees are getting together, you know, even if it's at a bar after work to talk about their job, their pay, how they feel about you as the boss or the supervisor, things that they like or don't like, that's going to fall under that concerted activity. They're allowed to do that. Incidentally, when I'm reviewing handbooks, I will often see, particularly with small businesses, where they borrow that language that says something to the effect of, you know, you won't discuss your pay with other employees. And we all like to justify this as saying, well, you know, it's just going to create tension. You know, if John tells Susie what he's making and Susie's making more or Susie's making less, that's going to create problems. And again, the Labor Relations Board says that employees are allowed to do that. So you don't want to create a situation where they feel like they can't discuss with each other what the working conditions are, what salaries are, those types of things. You certainly don't want to fire somebody, even if their off-duty conduct was embarrassing, if it's going to look like you're retaliating against them for something else. So, you know, again, John's complaining about how you're a terrible employer and you work everybody to death on Facebook. And he filed a complaint with one of the government agencies. and then you turn around and fire him, and it looks like retaliation for that protected conduct. It looks like retaliation for filing that complaint, and you try to justify it as, oh, no, I fired John because there was a video of him, getting arrested for drunken driving, and it embarrassed the company. Because of that tension there and that appearance of retaliation, that's going to create problems. And then, of course, if somebody is under an employment contract will often dictate when you can and can't fire somebody, and it's completely separate from employment at will. So you want to be careful in that situation. So your best practice, make sure that if you're going to have an off-duty conduct policy, you're really limiting it to issues that are going to impact the business's name, its reputation, and that you're protecting confidential business information. All right, you're not just on there, invading your employees' privacy saying, oh, you were out drinking on a Saturday night and I'm opposed to that for whatever reason. You posted pictures on Facebook that were unflattering and no one saw it and didn't affect my business, but I'm gonna fire you for that. That's just likely to create tension and problems that, I think are gonna be more of a headache than they're actually worth. So 2020, let's talk about drug testing, because medical marijuana is one of the big topics right now. So you can always test applicants and new hires, and sometimes you may even be required to do drug testing, particularly if you're a government contractor or if you're involved in a safety-sensitive industry, and there are sometimes specific rules around that. However, but your general, most of us small businesses that aren't necessarily, we don't have people out on the factory, it's not necessarily a safety issue. What are the rules around your drug testing? So for your current employees, you can certainly do a drug test following a workplace accident. You can do a drug test based on reasonable suspicion. And you can test an employee after they have returned to work following a positive drug test. The best way to do this and to comply with all these rules and regulations, because there are a lot of them, is to hire a company that specializes in doing drug testing for employers. Like, there are companies that's all they do. They're very good at doing it. If you're going to have a drug testing policy, you need to be involved and make sure that one of those companies is doing it. Getting this wrong can lead to all types of legal claims. We've seen cases where people have alleged discrimination because they either were fired or demoted or forced to take unpaid time off because of a drug test that came back, but it was a drug that was legally permissible. And so they've wedged that into, well, I was taking that job because I was over 40 and you were just discriminating against me because I'm an older worker. Other discrimination claims that come up, obviously, if you're going to have reasonable suspicion and send someone out for drug testing, make sure that reasonable suspicion is not based on a protected characteristic, right? Reasonable suspicion shouldn't be tied into race. It shouldn't be tied to age. It shouldn't be tied to gender. Again, even if you're in the right and it's just the employee is misconstruing it, it's still going to create a legal headache for you that, again, most small businesses don't want to deal with. Oddly enough, I've even seen cases involving invasion of privacy claims where a company tried to have the employee take a drug test or urine test in front of other people. Not sure what the rationale there was or what the employer was thinking, but it should go without saying that's a terrible idea. And then we've seen cases involving defamation claims where, for whatever reason, the employer felt the need to publicize the results of the drug test. Again, don't just sit down and talk to your PR person when you do fire somebody. Make sure you're talking to legal counsel as well. I cannot think of a good reason why you would want to publicize the results of a drug test for an employee that you fired. But yeah, that's a good way to get sued for defamation. Now, as I mentioned, medical marijuana is one of the hot topics. I think it's something that every small business needs to be aware of and to be thinking about, and how that may or may not impact your workplace. Regardless of what your personal feelings or political beliefs are about the situation, Ohio has permitted medical marijuana. However, Ohio did a very broad carve out for employers. So while medical marijuana is permissible, the law is very clear that as an employer here in Ohio, you can absolutely refuse to hire somebody, discharge or fire them, or discipline an employee who uses, possesses, or distributes medical marijuana. So you really can do with that what you will here in Ohio. Now, there's lots of talk and argument about whether or how that may change in the future, whether more and more states are going to increasingly go making recreational marijuana permissible and how that will impact workplaces. But for now, the law here in Ohio is that as the employer, you can do whatever you like, even though your employee might be legally using it as medical marijuana. And of course, in certain industries, if you're involved in any federal stuff, government contracting, banking, it's almost guaranteed that your drug policy is going to prohibit the use of marijuana, whether it's recreational or medical. All right, so that brings us to terminations, which are never fun. Nobody ever wants to have to fire anybody. It's not a fun conversation to have, even if the employee has it coming. Couple things to keep in mind. Ohio, like most states, is an employment at will state. So you can fire someone for any reason or no reason, but not a bad reason. So what are bad reasons? If you have an employment contract with that person, so not just an offer letter that was, hey, we're offering you this position, here are the details, but an actual contract with that person, you need to make sure that that termination fits within that contract, and that contract should cover when and how that person can or cannot be terminated. Bad reason, discrimination. In Ohio, our non-discrimination statute or act under the revised code applies if you have 4 or more employees. The catch is that in Ohio, the courts often count the owners that are working in the business as employees for the sake of reaching that magic number of 4. So particularly in small family-owned business, you and your spouse are the 2 owners, and then you've got 2 employees that work for you. You've now hit that magic number of 4. So you want to be very careful about firing somebody for a reason that may appear discriminatory. Our Non-Discrimination Act covers race, color, religion, sex, national origin, disability, age, and ancestry. I get the question a lot. No, our statute does not yet cover sexuality or gender identity. There's a lot of push for that to happen. It has not yet happened. How do you avoid claims of discrimination? I think that the best way to do that is to treat others the way that you would like to be treated. And if you have any questions about something that you're doing or getting ready or thinking about doing with an employee, and you've got any concerns about that, that's a really good time to sit down again with counsel or an HR professional. Other bad reasons to fire an employee: retaliation. You certainly cannot fire an employee for complaining about workplace conditions, for complaining about harassment, for complaining about discrimination. Once that complaint gets filed, you definitely want to talk to legal counsel before you let somebody go. And it doesn't matter what all that past history was, and oh, but they've had 6 write-ups in the last 6 weeks and they've been on a corrective action plan. That retaliation question is going to muddy the water significantly and create all types of headaches. You also cannot fire someone for lack of citizenship as long as they are legally eligible to work in the United States. So again, that's why you've got to have that I-9 form. You've got to have it filled out correctly, and you've got to document exactly which of their documents you looked at to verify their right to work in the US. But again, political beliefs aside, you can't fire somebody just because they're not a citizen if they have the legal right to work here. And same thing with hiring. And then of course, whistleblowing. So if you've got an employee that's complaining about illegal acts or unethical business practices, again, whether that's true or not, they're blowing the whistle on that issue. You'll definitely want to sit down with legal counsel before making a decision to terminate that person. Again, a lot of this comes down, treating other people the way you'd like to be treated, but it's also about being consistent. Because when you treat Susie one way and then you do something different with Jessica, that's going to lead to a lot of these claims of wrongful termination and discrimination. People see it, they see it coming from a mile away, and your employees are definitely talking about it. So are you being consistent in how you make decisions and in how you treat your employees? What does the handbook say about it? How have you dealt with these situations in the past? Is your decision fair and impartial, or is it, I just really don't like Susie, she's got to go, let me find some justification? And then of course, if it does really come down to it and you do end up letting an employee go, you should be aware that their final pay is due at the same time that your paychecks normally go out. So if that's the 1st and the 15th and they get fired on the 7th, their final pay is due on the 15th. You don't necessarily have to pay it early here in Ohio. You also don't necessarily have to pay out any unpaid vacation or paid time off, as long as you have a written policy that says you're not going to pay it out. So in the absence of such a policy, and this is why I keep saying, get your employee handbook, get it done and get it updated, because in the absence of that type of policy, you will need to pay out that unpaid overtime or vacation time. And then you should be aware that federal law does allow you to make deductions for unreturned property as long as that person still gets at least minimum wage for their last paycheck. However, Ohio requires a written authorization for you to do that. So if you're one of those small businesses that buys, iPads, cell phones, laptops, things like that for your employees, it is incredibly important that you have a written device policy. And that policy should dictate what will happen if that equipment is lost, stolen, damaged, disappears, whatever the case might be. And again, we see this most often with those disgruntled former employees who then disappear with that expensive iPad or laptop and don't want to return it. And you're going, well, geez, do I have to pay this person? They owe me for this, $1,000 device. So again, you need to have a written policy in place to cover those situations.